If you are in the federal sector and you're part of a reduction in force, then it depends what your benefits package is and what the annuity language says. This is a pretty complicated question. At the Spiggle Law Firm, we care not only about our clients, but all employees. That's why we created a free online community that you can join anonymously if you choose and interact with the members as well as our employment lawyers. We post updates on employment law news and answer your questions on the discussion board. Today, I want to answer some of the questions that our community members have asked that we think will be useful to many people. My complaint has been with OSHA for over a year now. Is there a limit to the time this complaint should take? Every time I call to get information on it, they just say, it's with the legal department. This is unfortunately very common with complaints to government agencies. They can take forever. And usually there is no particular deadline, particularly with agencies like OSHA, or if you're filing with the Department of Labor, some kind of overtime complaint there or complaint about the FMLA. They're just very slow. That's why it often helps to have a lawyer to speed that process along. Although having a lawyer can't necessarily shorten it, but sometimes they get better information from the department. So unfortunately, there is no particular time frame. Sometimes it can take these agencies years. The one exception is with the Equal Opportunity Employment Commission, or EEOC. There they have 180 days from the time you file your charge to complete their investigation. Now, it almost never gets done in 180 days. So what can happen is at the end of 180 days, you can do something called request your right to sue. That's a letter you need to go to court. And you just contact the agency and you say, I would like to request my right to sue. Now, if it's before the 180 days, the agency is not going to give it to you usually. Be prepared for it to take some weeks, sometimes a month or so, even after you make that request. What happens if you don't make the request? Well, then the process continues along. And again, like most government agencies, very slow. It can take many months, sometimes it can take years, but the EEOC is the one agency where you can request an end to the investigation to get the paper that you need to go to court. Other agencies like OSHA, I'm afraid that doesn't exist. What happens in a RIF, or a reduction in force, to career employees who are eligible for immediate annuity? Are they forced to retire? I thought it is illegal to force an employee to retire. This is going to be different between federal and private sector. If you are in the federal sector and you're part of a reduction in force, then it depends what your benefits package is and what the annuity language says. This is a pretty complicated question, and I don't think I can answer it here based on these sorts of information. I really do think you should hire an attorney or go contact an attorney. You can pay for an hour of their time. Somebody who does federal sector work if you give them enough details. And this is true in the private sector too. It depends on what your benefits package says. The annuity is usually with some investment or insurance group, and it'll be subject to a separate agreement, and you'll want to know what that says. Avvo.com, AVVO.com is another site you can go to where you can get legal questions answered. Sometimes you're going to ask them for free, so you get what you pay for. Attorneys will respond, and you'll have to decide whether or not they're giving you good information, because you'll get all kinds of attorneys responding. You don't want somebody who specializes in real estate answering this question, just like you wouldn't want to talk to me if you're trying to sell your house. Great question. I would need more details. I think you should go talk to a lawyer about that one. My employer laid off a bunch of people and used the WARN Act and put everyone on administrative leave for 60 days. Now they're saying that the 60-day notice period will be deducted from our severance. Yeah, I have spent time helping with the transition, and I am tied to the organization during the 60-day period. That is, I cannot work with my clients until after the WARN period, when I officially be no longer an employee. They are saying that there can't be, quote, duplication of benefits, but these seem different to me. Is this legal? Your situation raises a complex intersection of WARN Act obligations, employment status during the notice period, and severance pay practices. Here's a breakdown that might help clarify the legality. Under the Federal WARN Act, or Worker Adjustment and Retraining Notification Act, employers with 100 or more employees must give 60 calendar days advance notice of mass layoffs or plant closures. During the 60-day period, affected employees typically remain on payroll, often with benefits intact, may or may not be required to work. Some are placed on administrative leave or garden leave. The WARN notice period is not the same as severance. It's a legal obligation to give notice or pay in lieu of notice. Severance is generally a voluntary benefit, unless your contract or a policy guarantees it. WARN notice pay is required by law. either by keeping you employed for 60 days or paying you in lieu of that notice. Some employers subtract the WARN notice period from severance by arguing that both serve similar financial functions. However, this is controversial and potentially problematic, especially if you're still performing duties or are restricted from working elsewhere during the WARN period. Your employer claims there is a duplication of benefits, but based on what you've just said, you are still an employee during those 60 days. You are restricted from working elsewhere, especially with your clients. You are doing transition work, meaning you're providing value to the company. This suggests you are earning your pay during the WARN period, so deducting it from severance could be seen as unfair or unlawful, depending on your state and the specifics of your employment agreement. This area can be legally gray. Some courts have allowed employers to offset severance by WARN notice pay, but usually only if the employee was not working or was paid in lieu of notice. If you're still working or being restricted, courts may be more sympathetic to the employee. Some states have stricter minimum WARN laws, which may provide additional protections. So, what can you do about this? Check your employment agreement or severance policy. Does it guarantee severance? Does it mention offsets? Consult a local employment attorney, especially one experienced in WARN Act matters. Document any work you've done or limitations during the WARN period. This strengthens your case if you claim you are earning that pay, not receiving a duplicate benefit. I hope that helps. I want to thank our Legal Leverage community members for sharing their questions and experiences with us. You can join our free online community at spigglelaw.com/community and start asking questions today. At the Spiggle Law Firm, we don't just represent employees, we empower them.